the petitioner. They're first going to present their case, their argument for 15 minutes. That's going to be followed by the rebuttal by the respondent, which is the Elections Board and the Winters-Ramos ticket. And then after that, the Judicial Board will ask questions to the argument printed by the petitioner. And the same thing is going to follow with the respondent presenting their argument and then a rebuttal from the petitioner. The respondent gets 15 minutes as well. The rebuttal from the petitioner gets 5 minutes. And the Judicial Board will ask questions. Okay, so we're going to begin with the petitioner presenting their case.
May I just read the complaint?
Absolutely.
Be it known that this document is a formal complaint levied against the Winters-Ramos ticket for bylaw and elections code violations. Statement of fact. On March 7th, the Winters-Ramos ticket established a tabling site outside of the cafeteria building on the Washington State University Vancouver campus. At said tabling site, Winters-Ramos and their campaign team, hereby referred to as Winters-Ramos et al., engaged in active campaigning, displaying campaign materials, and encouraging students to vote for them. Be it also known that Winters-Ramos et al. Had on-site a personal computer on which they were accepting student votes. By encouraging and accepting student votes on-site, the Winters-Ramos ticket is accused of establishing an unauthorized polling station in direct violation of the ASWSUV bylaws. Be it also known that a polling station is defined as a building such as a school designated as the place to which voters go during an election to cast their votes. By establishing this unauthorized polling station, the Winters-Ramos ticket was in direct violation of ASWSUV bylaw 620.01. Furthermore, having established said polling site and actively campaigning within the boundaries of the polling station, Winters-Ramos et al. Were in direct violation of ASWSUV bylaw 620.04. ASWSUV bylaw 620.01 states, the alcove in the administration building shall be defined as a place for students to vote. An alternative polling site may be used at the recommendation of the Elections Board and approval by the Senate. ASWSUV bylaw 620.04 states, by 8 a.m. the morning of the election, candidates shall remove all of the campaign materials from all areas within sight of the polling sites. Any campaign material put back at a polling site area after the area has been cleared shall be considered to be an elections code violation. Be it also known that establishing an unauthorized polling station in the Winters-Ramos ticket was in direct violation of Washington State Elections Code, RCW 29A.84.510. Additionally, Winters-Ramos et al. Were witnessed directly influencing voters as they cast their ballots. In some cases telling them that they did not need to vote for senatorial candidates. Such influence is considered unlawful and violates Washington State Elections Code, RCW 29A.84.360. RCW 29A.84.510 states, acts prohibited in voting. 1. During the voting period that begins 18 days before and ends the day of a special election, general election, or primary, no person may within a voting center A. Suggest or persuade or attempt to suggest or persuade any voter to vote for or against any candidate or ballot measure. B. Circulate cards or handbills of any kind. C. Solicit signatures to any kind of petition. D. Engage in any practice which interferes with the freedom of voters to exercise their franchise or disrupts the administration of the voting center. 2. No person shall obstruct. That part doesn't really apply to the law, so I'm going to skip over that one.
Okay.
RCW 29A.84.630, influencing voter to withhold vote. Any person who in any way, directly or indirectly, by menace or unlawful means, attempts to influence any person in refusing to give his or her vote in any primary, special, or general election is guilty of a gross misdemeanor punishable to the same extent as a gross misdemeanor that is punishable under RCW 98.20.021. Lastly, be it known that in violating Washington State Elections Codes, RCW 29A.84.510 and RCW 29A.84.630, the Winters-Ramos ticket was in direct violation of ASWSUV bylaw 650.03, which states all candidates or sponsors of ballot issues shall ensure that they do not break laws, ordinances, rules, or regulations of Washington State University, Vancouver, the City of Vancouver, Clark County, and the State of Washington while campaigning. That essentially, they established a unlawful polling site. In that polling site, they were campaigning. They had materials, they had posters, and they were influencing people how to vote. I first became aware of this when I walked by the Capitol to get some water because I was out in the campus campaigning, as were the other tickets that day. I thought it was unethical. I brought the issue to Elections Board and to Phil Backup, who is our interim advisor. I was told, 10 minutes. 10 minutes. I was told to consult the bylaw, finding a bylaw that was being directly broken, to report back to the Elections Board. I pointed out 620.01 was in violation and asked that the unauthorized polling station be shut down for the day because it seemed unethical and it was in violation of bylaws, and nothing essentially came of it. It did continue for the rest of the day, and so here we are today with the point. That's all I really have for my part.
Okay. So we've heard the presentation from the petitioner. Now we have a rebuttal from the respondent. You guys have 5 minutes to rebuttal directly to the petitioner.
Okay. So the Winters Ramos ticket did not violate bylaw 620.01. The Winters Ramos ticket did not create a polling site but merely continued campaigning and did so in an unusual form. Campaigning is defined in bylaw 650.01 as the use of any print, electronic, or verbal presentation in the name of any candidate or ballot issue. In accordance with bylaw 650.04, all unusual or new forms of campaigning must be approved by the Elections Board. Approval to the Winters Ramos ticket to campaign in such an unusual form was given via email on Wednesday, March 5th. And we have that email. We also have an email from Phil to Kim Estes, telling her about the table that was going to be set up. Additionally, the bylaw was not violated as the Winters Ramos party posted signs alerting voters that the table was a campaigning station and not an official polling site. Bylaw 620.04 was not violated as the Winters Ramos ticket removed all campaigning materials near voting sites in accordance with the request of the Elections Board. The materials displayed on their campaigning table cannot be at question as they were not near a polling site but a campaign site. The Elections Board during the time of elections is invested with the power, I quote, to interpret the elections codes whenever necessary. That interpretation shall be binding, end quote. Bylaw 611.03 Section A. As seen in the letter from the Elections Board to the Winters Ramos ticket, the computer and table were permitted. The Winters Ramos ticket did not violate bylaw 650.04, as the ticket and campaign team did not campaign by any polling stations and remained within the permitted areas. It should be noted that there were no parameters constricting the movements of campaigning within the free zone outside of VDEN given to the campaigning tickets, and we have email proof of that. In regards to the allegations that the Winters Ramos ticket violated the revised code of Washington, first and foremost, there has been no evidence of any reliable sort brought to the Elections Board or the defendants prior to the hearing. Moreover, the ASWSUV Judicial Board is bound to only interpret the ASWSUV Constitution, which is bylaw 410.01, and therefore cannot address the unsubstantiated, conjectured allegations in relation to the RCWs that were brought by opposing representation.
2 minutes.
Okay. That time is supposed to be a rebuttal to ask questions to the petitioner, but is that your presentation of your whole case then? Or do you
Not
have,
all of
okay.
it. We have more.